Good morning, Mr. Gartin.
Good morning.
Come on in and get settled, and when you are ready, you may begin with your opening statement.
Okay. Well, good morning, Ms. Roberts and the members of the Commission. It's great to be with you again. I appreciate the work that you're doing on this Commission, and I thank you for the confidence you place in me just recently to be a finalist of one of 16. It was a very strong field, and I appreciate the confidence you place in me just recently. I want to assure you that I take nothing for granted, though, and so this is a brand new slate of candidates. You have 11 strong candidates. And as I serve on the District Court Commission in 2B, I find myself sometimes interviewing someone that I've interviewed 3 or 4 times before. And there's always this temptation to say, well, I sort of know this person. I don't have to spend as much time with them this time around. And I know that there's an element of discipline on your part that's involved in saying, I'm going to make sure that I provide a fresh set of eyes on a candidate that I know fairly well. And so what I do is I sit down with a big cup of hot tea and I say, my goal is to find 2 or 3 new things about this candidate that I didn't know to help me in that next process. And so what I'd like to do is just offer you a couple of 2 new things about me and give you an update on an old one and then open it up for questions. That's what I would most enjoy doing. And so a couple of new things. First and foremost, I was very humbled to receive a call from Judge Gail Vogel, and she called to say, Tim, I want you to place me as a reference on your application materials. Now, if you know Judge Vogel, that's a very big honor. She served in the Court of Appeals for 23 years and served with distinction and still serves as a senior judge. And she models, I think, a service as an excellent judge, but also the kind of character that we want to see in a judge. And so her words of encouragement, she said to me, Tim, we need you in the appellate courts. We need someone with your background, your transactional background on the appellate courts. And so I don't know what that means to you, but it means a great deal to me because of the view I have of Judge Vogel. Secondly, in the spring, I was asked by Iowa State to apply to teach a business law section. And this has been a great experience. I teach 130 primarily sophomores and juniors. They're primarily in accounting, finance, transportation, logistics, and other business areas. And a thought that I've had as I've gone through the semester is, will we have courts that will be able to hear business-oriented matters in a way that will be good for Iowa? And so we hope to keep many of these students in Iowa. And I think about the kind of judiciary. Will we have a court system that has people that will be able to hear transactional matters in a way that's fair and helps the development of our business community in Iowa? And a final thing that's more of an update, I continue to give a lot of attention to continuing legal education in Iowa. It's important. A long time ago, I decided I needed to have a new sort of focus and motivation in my own practice, and I decided that motivation would be, I want to be the kind of lawyer that I would want to have as a client. And so part of that, I would not want to have a lawyer who is not committed to their own learning and development. And so continuing legal education has become a big role for me. I recently gave an important lecture on ethics at the University of Iowa Real Property program on confidentiality. And I'll be speaking for the bar at the end of the month on the attorney-client privilege. And then in the spring at Drake, I'll be giving a program on statutory interpretation. And all of these are important, not just for me personally, but I hope are of great benefit to Iowa lawyers. The final thing I'll leave you with is that I sent you a series of letters on Friday, and these were letters primarily that you did not have. There were 3 letters in particular that were sent to Governor Reynolds as part of that process that I think are particularly important. One of them from Dwight Dinkla that I, again, was very humbled to have received, and I would encourage you to review that. And so with that, I'd be happy to take questions from the Commission today.
Thank you. And we'll begin with Mr. Horbach.
I have no questions.
Thank you. Mr. Spees.
Thank you. Good morning, Mr. Gartin. Mr. Gartin, I've been very impressed by your involvement in the
education of the legal profession in Iowa and your aptitudes in sharing what you've learned, what you know with other lawyers. I'm curious about what your observations are about the legal profession in Iowa in general. Is it keeping up with the times? Is it as astute and intellectually involved as it should be? And how do you see that observation playing a role in your position as an appellate judge?
Well, thank you for the question, Commissioner Spies. I do think it's imperative that attorneys make this a focus of their own practice. It tends to be a box that we check. I've got to get my CLE hours in. And when you look at it as an obligation, as a box to check, it becomes sort of that. And I hope that I'm contributing in both real estate as well as ethics to the improvement of continuing legal education. You see, the reason for this is that if we care about our clients, then we'll care to continue to improve ourselves and continue to learn new things. I do have some concerns. Particularly in the area of ethics, I have attended a number of ethics presentations that frankly I felt were a bit of a waste of time, and I thought to myself, I'm never going to get that hour of my life back. And yes, maybe I've been able to check the box, but I've not grown, I've not learned anything. And so my goal is that anyone who comes to a program that I give, I have a solid set of materials for them that will serve as a resource, but they also walk away having learned something, developed a better handle on the case law or some area of statutory law. Thank you very much for that question.
Mr. Goodman.
Thank you. Mr. Gartin, thank you for your application. 2 times ago when you appeared before this commission, you held up the advance sheets and said, I read these, which is maybe unusual for a transactional real estate lawyer as opposed to a litigator. I was impressed by that. I think the question that needs to be answered is, how would the Court of Appeals benefit from having a real estate lawyer, a property lawyer, a transactional lawyer on it? And can you give me an example of a case that you have read where you said that outcome would have been different if it would have been informed by someone who was a transactional or real estate lawyer? And finally, I'd like you to comment on why should we pick people from private practice as opposed to those who have served on the bench and have experience judging cases if they're going to sit in judgment of other judges who have either heard or are to be affirmed.
Okay, well, several components to that, and if I miss something, please come back to me. So first of all, in aspiring to serve in the Court of Appeals, it would be foolish for me to say I'm only going to be concerned with transactional cases. So I have a background in criminal law and juvenile law that will help me process these cases. And I'll give you an example of that. So right now, we're working through a number of cases on appeal where the Albright decision is working its way through. So in Albright, the court said that defendants are entitled to a hearing on the issue of their ability to pay restitution. And one of the justices that you helped send to the Supreme Court, Justice Christensen, was vitally involved in that. I don't know if you saw the oral argument, but you should be very proud of the role that she took in that oral argument. That case is having a rippling effect in the way in which sentencing hearings are taking place, but also for those who have already been sentenced. I have a background in which to think about the implications of those kinds of cases. But in the area of transactional law, I do think that there are cases that my background would be of help. And I have to be a little careful with this, but let me give you a very startling example, and that's the Westlakes case. In the Westlakes case, the court said that a right of first refusal that was older than 10 years is void. And I want to bring you into my world as a transactional lawyer. This was a devastating case for lawyers who have relied on the presumption that there wasn't any kind of 10-year statute of limitations on that rule. And so this may come back at some point. If I was allowed to serve in the Court of Appeals, I want to be careful a little bit how far I go into the weeds. But if someone had a background in transactional law, they would have had a set of lenses to know, hey, wait a minute, if we go this direction, this is going to have major implications for the people of Iowa and for farmers and for people who relied on what had been a rule of law for decades. And so that's an example of where I think having a transactional attorney on the team would be of great help. And finally, I think to your last question about having attorneys from private practice, so I am in the process of helping to select judges. And I do have a high view for the work that the district court trial judges bring. But there's a reason why that it's not a requirement that you serve as a judge as a prerequisite for service here. I think those who created those rules recognize that a private practice attorney brings something to the table, brings in a wealth of experience of someone who works with clients day in and day out, helping with those needs. And so at some point, being on the bench creates some distance from the people of Iowa that we serve. And I haven't had that distance. For 23 years, I've been getting up in the morning, and I help people. And I was just talking to my staff just yesterday about this, that part of what I love about my work is I get up in the morning and I help people. And I find that very rewarding, and I hope my staff finds that very rewarding. And so I think having that set of lenses would be of great help to the appellate bench. Did that answer the different prongs? Thank you for your questions.
Mrs. Sinclair.
No questions.
Mr. Bevel.
Mr. Gartin, I look at some of your memberships that you've listed, and then I know about some of your activities in the community. And I go, huh? Help me understand how you view people, diverse groups of people, and how the law should apply.
Yeah. Thank you for that question, and it's worthy of a much longer answer than I'm going to be able to afford it. This idea of the rule of law is part of my fiber of who I am as an individual, but particularly as an attorney. And I think we have a duty as attorneys to be catalysts and to be advocates in our community for the application of the rule of law broadly. There's been a bit of a journey in my own story over this. And so for the last 4 or 5 years, I've been vitally involved in our local NAACP chapter. We had a meeting last night, and part of the way that I wanted to contribute was I said, well, why don't I put on a program on Brown versus Board of Education? It's a case I knew a little bit about from law school, but it had been a long time ago. My friends, that journey was a rabbit hole that it took me a year to get out of, and I'm still not completely free. And what I mean by that is the story of Brown versus Board of Education is not just a story of African-American history, it is a story of all of our history. So all of us need to engage and understand the story. And this is not just a factor for the Deep South, it's here. So practically, that's very theoretical. Practically, what does that mean? In Iowa, students of color are behind in our education system significantly, but they're also disparately treated in our judiciary system. So in the juvenile law system and in our adult court system, people of color have a higher representation in our justice system. And I want to tell you that there's no easy answer to that. But what it's important is that you should find people to go on the bench that have a heart for this issue. And so part of what my goal has been is to be an advocate for issues of civil rights in the state of Iowa. And I think that's an important factor of who I am as an applicant. Thank you for asking that question.
Thank you.
Ms. Stanger.
I will pass.
Ms.
No
Pearson?
question.
Ms. Law.
Since Mr. Goodman and Mr. Bell took my questions, I'll pass.
Mr. Gray.
Yeah, pretty easy question. If you are selected as the governor would put you on the Court of Appeals, how many of these extra activities do you have to give up? Are there things you cannot do because you're now on the Court of Appeals?
Thank you for that question. So life is short, and I have made a goal to fill my schedule with things that are important to me. So it's always been a difficult balance with family. I have 4 children, 27 to 18. And so it's always been that effort. All of you in this room have had to strike this balance if you have a family. And so there are some things that I would have to give up that are meaningful to me. I serve, and this sounds a little nerdy, I apologize, but I've been serving on the Underground Storage Tank Fund Board. I know. If that doesn't get me on the Court of Appeals, what will? But I actually have really found that very meaningful work, and I hope have contributed to that. So there are things that by law I should step down from, but I would take this work very seriously. Judge Vogel gave me that call for a reason, and I would make it my work to make sure that she made a good decision and that I would honor your confidence. And so I would make that my primary mission to do the best job I could for the 3 million people of Iowa.
Thank you.
Mr. Bloom.
I'm going to pass. Thank you.
Ms. Conover.
No questions, thank you.
Mr. Sukup.
Thank you. Mr. Gartin, you answered part of your burst of energy. You're doing the classes at Iowa State. What other items? You always seem to have quite the activities going on.
So is there...
Besides the Iowa State classes this semester, what's your other burst of energy being tied up with?
Yeah. So I actually serve on the city council. I'm up for re-election. Not to make this too complicated, I don't have an opposing candidate, but I'm still pretty involved in activities right now in Ames. So it's sort of a high energy time right now. It'll back off here in a week. So,
All right. Thank you.
yeah.
Ms. O'Brien.
No questions, thanks.
Mr. Berger.
No questions.
Ms. Valentine.
Thank you for your application. I'm curious if you have any ideas or suggestions, or if there's any need for any changes as to how the Court of Appeals functions or does business.
Wow. So I do have some suggestions, and I want to approach this with respect. So there are a couple things. One is, I think it would be worthwhile for our courts to give a strong look at the way in which mandatory appeals are done. And so you have a right to an appeal in a juvenile setting, and a large number of those cases really don't have any merit. And I've handled some of those. And you have to work very hard to find a basis for an appeal, and you end up just going ahead and finding something to write about. And as a result of that, we have a large number of cases that come up on appeal that the lawyer should have been able to serve as more of a gatekeeper role and say, this is not a case that really merits further review. So as attorneys, we've performed that function as a gatekeeper. If someone comes to you and says, I have this case I want you to bring, and you meet with them and you say, that's a crazy case, there's no merit to that, I'm not going to take your case. That's a gatekeeper function that all of us have, but that does not apply in the appellate courts. And so I represented parents primarily who lost their parental rights, and they said, Tim, I want you to appeal this case. And I said, I don't think you have any merits to this appeal. I want you to appeal it anyway. And so we did. The problem with this is, and I appreciate the question so much, is that in the sea of appeals that are taken, there are some cases that really should be reviewed carefully. And so I worry a little bit that the sea of cases is diminishing and sort of watering down those cases that really deserve further review. The other thing I would say broadly is that the number of cases between the Supreme Court and the Court of Appeals needs to be reviewed. I think that's a subject that you've considered. I echo that concern. I think the workload needs to be revised. Thanks for that question. It's a great question.
Mr. Wojcik.
One of the things that I find just awesome about you, Mr. Gartin, is you live deeply, you think deeply. There's a lot of work to do on the Court of Appeals, and not every decision can be the catcher in the rye, and you kind of alluded to varying levels of cases. Do you think you'd be able to adapt to turning out the amount of work and maybe not going down a rabbit hole, to your Brown versus Board of Education reference, on some of the things, because it'd be hard to be effective.
That's right.
Do you think you can manage that?
Yeah, that's a great question. And so thankfully, not all cases are going to be those kind of major precedents, so I appreciate that question. You know, one would hope that the vast majority of cases that come up in the appellate process are affirmed. We don't want to have the majority of our cases be cases where we're overturning the work of the district court. So we would hope that the vast majority are in that category. So to answer the question, I work hard in the course of my practice. The 50-hour plus work week is normal for me. And so what I can promise to you is I would work very diligently to give the kind of meaningful review that every litigant is hoping for. That's what I can guarantee that I would provide to you. And so in those cases that really just need to be reviewed in a timely fashion, I would be able to do that. But in those cases, and I would suggest the rare cases that require a deeper dive, I believe I would have the horsepower to do that and a willingness to do that.
Thank you.
Thank you very much.
Mr. Gartin, thank you for being here today. We wish you well.
Thank you very much for the time today.